Please, Your Lordship.
Yes.
Bishop's, I would like to mention hearing item number 29, 50 and 31, Your Lord.
Why?
One of my senior, Mr. Ishimomi, is unwell today.
So
if
now we had a meeting. Saturday there is a court. So what me and my sister was thinking is that we'll put it on Saturday. We'll hear it very conveniently then for you. We'll adjourn it today, but on Saturday, if you agree to that.
next week, my Lord, we say next week.
See, these matters were being adjourned every time it was being listed for the last few occasions. Why? It's a small issue. So you give me a date when you will actually do the matter.
Next week.
Next week.
Sure. Next week.
It would be an auspicious day. It's got to do something with the church also, so we'll have to give you an auspicious day for that.
Mr. Lordship, my team will not be there. Yes, they will be leaving for Mahokjong on next week, so perhaps maybe the week after.
Fine.
It will be 18th.
18. Can it be on 18 then? Both parties?
No.
Prayer is made on behalf of Mr. You are making the prayer on arguing counsel is?
Ishimomi.
Prayer is made on behalf of Mr. A. Zimomi, learned counsel appearing for the petitioner for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the respondents. Full stop. Prayer accepted. Full stop. As agreed to by the learned counsel for the parties, registry to list this matter again on 18 to 2026, 29, 30, 31, 32, 33. Huh?
32 and 33 are different matters, madam. However, I have a similar prayer for 22 and 33. So 32 and 33 we can have it next week, madam.
No, we'll have it on 18th together. Because 18th we'll have it.
May I wish?
May it please your lordship.
Yes, Mr. Bull.
My lord, this item number 15, my lord, with the consent of the other side, can I say that it did be taken up on 18th, my lord? This was fixed on 14th of January, but it came up suddenly. And I am not able to be present personally.
Mr. Barua, how is this writ appeal maintainable in the first place? You had consented to the directions passed by the learned single judge.
My lord, there is a certain difficulty there.
It's not a case wherein the judgments that you're trying to rely on, the documents are beyond the last date of submission of application. This is not a case here. The documents were there, the originals were misplaced. And you said before the learned single judge that, okay, fine. If he gives a notary, if he gives a fresh set of documents from the same very council, we will accept it. They have given it. Why?
Lord, I will explain. I desire to explain the facts in person, my lord. That is why
we are very comfortable in hearing you online also. You can make submissions today online.
My lord,
we'll be very happy to hear you online.
My lord, can my lord fix it on 18th, my lord? There's a difficulty. I was taken unawares today. I have some matters also fixed in the High Court as well.
Unawares? It was fixed on the last date today?
No, my lord, on 14th of January, I had fixed it.
Mr. Barua, if you have any problem in the first half, we can come back in the second half for you. No problem.
My lord, may take it up that there's a difficulty. That is why, my lord, I would not make this clear otherwise. Mr. Rumsung is there.
Mr. Rumsung has serious objection to adjournment of the meeting.
My lord.
Mr. N. Barua, learned counsel for the applicant, prays that he be granted an accommodation today and the matter be taken up on 18 to 2026.
How about 25th?
25th on 25 to 2026. For some, prayer is not objected to by the learned counsel for the respondents. Accordingly, a registry to list this matter again on 25 to 2026. I'm making it a point, no further adjournment. No
I'm uploading.
adjournment shall be granted in the matter to either of the parties on the next date of listing. It's a concept order. You got to cross that hurdle.
My lord, I realize that fact.
Okay, okay.
Obliged.
Yes.
Lord, I'd like to mention item number 34. Lord, here by the last order.
PCR has not been received.
Yes. The CR is yet to come.
Okay. What we do is, we'll let it reach, we'll pass the orders. You need not be here. We have heard you. We'll pass the orders.
No, no.
Well, Mr. Lordship, my lord, I'd like to mention item number 19 to 27. I'm mentioning on with the consent of the opposite party. My lord, similar case is pending with number 2 of 2025. So these are similar case. So let the matter be listed along with.
You are for the state.
Yes, my lord. Let the bill number 2.
What is left here now? What is left here? The coordinate bench had passed a similar order.
Yes.
30 years beyond retirement. That matter went up to the Apex Court.
Yes.
Apex Court has upheld the matter. So what can we do here? We'll just have to.
Well, the leading case is pending.
No, leading case, we'll consider these cases. Leading case will get covered by itself.
Worship, I in WA number 2 of 2025, it's a state appeal. Because of the Supreme Court has passed the acquisition of law to is left open.
That is for the Supreme Court to consider. For us, the coordinate bench's judgment is binding. And now that it has been affirmed by the Supreme Court, more binding. Need not be. SLP has been dismissed. As far as the issue is concerned, it is settled. You go upon before the Supreme Court in the next round of litigation, issue will be considered.
About with this case because WA2 is the leading case.
Yes, every cases are leading cases here. Every case is. Now tell me, what is the distinguishing factor here then from the other cases?
Same facts.
Same fact situation. So we are considering it today, ma'am.
No, it's not the same facts. Same facts of the case.
Issues.
Yes. Because here in the case, there is a much delay in filing the writ appeal. After they retired, only they filed the writ petition. Then the learned civil judge, they have not come within the purview of the OM, which is the scheme for.
Madam, you seem to be well prepared. Convince us when the matter is called up.
Lordship, I have not in this matter, Your Lordship.
You assist him.
Lordships are very 1958. There's my senior, he's been long. Lordships let me maximum of 2 weeks. My senior's embarrassment.
Oh.
58.
Father passed away. A prayer is made on behalf of Mr. Limam Pawang, a learned counsel appearing for the appellant for an adjournment in the matter on the ground that he is in bereavement. So prayer is not objected to by the learned counsel appearing for the state respondents. Accordingly, registry to list this matter again on
Of 2 weeks, 18.
18 to 2026. For admission.
Item number 1.
Yes, Mr. Masa, what is the development?
Lordship, possibly, as per the order dated 25/11/2025. Lordship, why is that? It was filed by KHIBCL. It was filed only last district. That's how.
You took some time on the last date.
My lord, I have gone through that, I filed. If your lordship, kindly allow me to read the order for your convenient.
Madam, order
25/11/25.
25/11/2025.
This bench.
Yes.
Yes.
The order dated 24/9/2025 to highlight the fact that the respondent authorities have taken all the requisite steps for having the road constructed by ensuring that the same is protected from natural calamities. It submits a packet 1 and 3 award to respondent number 19 for smoke management and full barrier around change 124 of the respondent number 19. However, the peer prepared for a work in question tends to prepared without taking the whole area into consideration. Due to the debris falling from the heights above, the extent to which the management activities were undertaken has resulted in total damage of the works carried out in the matter. He has further submitted the works related to the river protection and road widening also has not been carried out after due scientific examination being undertaken, and that we are prepared for all parameters were positive. This court has the assistance of the authority engineer who has clarified that the consultant was appointed to study the entire hill area involved in bracket 1, 2, 3 between challenge 124 and 127, and the technical data which was so required have been collected and the same is presently being analyzed. He submits an analysis of the data collected is presently underway by the experts, and the DPR in this connection will finally prepare within a period of 2 months from today. He also submits that in connection with the viaduct to be constructed in challenge 164. The data required have been already collected and is being analyzed by the experts. He submits that a physical report in connection with same will be submitted shortly and draft the NHITC authorities will take the decision thereof. He also submits that an obtained in this condition will be given to respond. The next step of listing to an affidavit filed by the NHITC authorities with regard to the river protection works, the Learned Council for NHITC has submitted that an update plan will also be brought in report on the next step of listing. The issues highlighted here now shall be addressed by NHITC authorities in the matter indicated above by done today by the filing and consolidated affidavit before this court. On the next day of listing, the NHITC authorities shall also incorporate in the said affidavit. None of this are important. Any further precautionary steps that may be taken so as to ensure that the route unbeing constructed is open to traffic all around the year and the same is not damaged as has been observed with regard to works already carried out. The NHITC authorities in its affidavit shall also highlight as to why the construction activities carried out with regard to package 1, 2, 3 around challenge 124, challenge 127 came to be damaged, and as to why the factors leading to the damage of the construction carried on terrain was not foreseen by the experts of the NHITC when the DPR for the purpose was so prepared. Further, the affidavit shall also disclose as to whether the defect liability period for package 1 and 2 is in currency or has expired. NHITC authorities shall also in the said affidavit incorporate the status with regard to steel bridge constructed with challenge 155, along with the progress of the works will go in the package 3. The Chief Engineer PWD National Highways has filed an affidavit on 24/11/2025 and has brought a report and letter of acceptance issued to S symbol such and such with regard to work of one-time improvement from 127 to 185 kilometers under Kohima division. The learned senior council submits that the contractor now appointed for the second work being also included as a party respondent in the proceedings. In the present proceedings, accordingly, the registry is directed to embrace such and such as respondent number 21 in the present proceedings. The name of the newly included respondents be incorporated in the guest report, and notice in this condition be issued by the registry to the newly included respondent number 1 to learn additional AG. So these are the directives. Lordship, accordingly, I have received a copy of the affidavit filed with the NHITC authorities in compliance with this. So the operation is present pay and from paragraph 2 onwards, page 4.
Where is that affidavit? It's an affidavit by 6 and 7.
Yes, Lord. Point wise, Lord, of paragraph 2. If Lordship may kindly go paragraph wise and request the authority engineer to highlight.
No, just give me your perspective on that, then we will get back to you.
Although if lordship may kindly, we go by paragraph wise.
So what we wanted them was that the undertaking was, okay, the road has, the earlier works have gone down the train, and they are now taking up a review of the whole hill, entire hill, and package number 1, 2, and 3 between chainage 124 to 127. Technical data would be collected, analyzed, examined, and a DPR in this connection would be finally prepared. And a feasibility report would be submitted, and NHIDCL would be taking its call. Then what has happened is that with regard to that ancillary thing, river protection works and that bridge, viaduct. So, yes, you're Mr. Sajujos. Yes, Mr. Josh. What exactly has happened after the last day?
The DPR is in the final stage. Designs are almost
No.
completed.
First is that you made a survey of that area.
Yes,
You have got the entire hill
entire package 1, 2, 3. Then there is data and Bali data.
done,
Completely analyzed.
and now you have the data with you.
Yes.
That has been analyzed.
Analyzed.
Your experts have gone through that,
Yes.
and you are preparing a DPR.
Designs for individual locations.
Okay.
That is in the final stage.
Hmm.
Expected to be completed in another 2 months' time.
Another 2 months time.
Design and then peer reviews are happening.
Hmm.
Designs again get reviewed by the experts.
Hmm.
It could be.
So by the time we will have the rainy season again.
Because it's a long.
See, the problem is if you work here in a rainy season, that would be working like
Anyway, this season we are up to.
pouring a bucket of water in the sea. It doesn't make any difference. You don't have even a trace of that.
It's going to be a major project.
I know that, but we passed this order in November. So 2 months would have been January. So work would have should have started by now, so that by the time the rains are here, you have the base at least completed.
There are about 160 locations identified, which are all having different type of.
Mr. George,
different solutions.
Mr. George, you are an expert. You means your organization is an expert in this. We are not. So this problem is not something that has come up recently. This problem was there when you started the first work. You prepared the first DPR. Why were these aspects not taken into consideration?
For the hillside, this landslide protection DPR was not ready at that point.
When I was coming this time, I remembered about that. I was not aware that this matter is being listed. So when I was coming I came a little bit when there was sunlight. It was in the evening hours. So when I was crossing, I just crossed Dimapur and I was coming up, the works were going on there. So I found the place to be barricaded, to be covered by some metal nets. Then I stopped my car, I got down. Then I found that above, at a certain height, maybe 20, 30, 40 feet, 30 feet above, you have put some thing, just the hills are there, you have put a net like this.
For barriers.
There is a net like this and a net like this.
For barriers.
Rope fall barriers. Then I just watched how far the height further than that. I found that the height is again another 20, 30, 25 feet, which I could visualize. Now, if a stone is coming out from there, this thing will not stop it. It will come directly to the road and the vehicles would be in trouble. Whose ideas are these actually?
People were kids in the past few years.
Yes.
And
Mr. Jones, but these things are to be factored in by you experts. Because a novice like a person like me can visualize that. Why not an expert like you? You means your organization not being able to visualize that.
Send the entire strata studied, including the up to the hilltop, to find the 350 to 500 meters of the total height of the hill, the Sriduguru area. The entire strata is collected.
If this was being done by some private person, I would have understood that he has done it because he has constraints, or financial constraints, or even maybe technical constraints. But you people doing it, this is too much.
Limited. Our land was only.
I don't know why this is not getting this. If it goes into the media, it might put you in a very bad light.
Constraint with the NHDCL was the ROW. it was limited. So the protection measures, whatever is done, only up to
The
the.
hill was not given to you.
The complete hill is not.
No, actually, on that issue, since I am appearing in this case since 2019,
Huh.
in all the cuttings I was appearing, he's new here. So at that moment of time, I was raising serious objection on the ROW. That it is not sufficient. In fact, the contractor who was cutting the hill also were seriously objecting that in view of the fact that ROW is not properly given to them, you were not able to do proper benching because you need to sloping.
Because if this
not-
hill has to be protected, you cannot protect it halfway. You will have to work from the hilltop to the bottom.
Lordship, at that point of time, the HIPACL, the so-called expert, were vehemently taking a stand that ROW is sufficient when during the hill cutting. Now, after what has happened, now they are blaming everything in ROW. Who is responsible for the ROW? Who is acquired?
They have acquired.
He has acquired. He's now in a very difficult position because that time the authority engineer was their friend. Now he's a new authority engineer. So from day one, in fact, I agree with the state government when the state government was giving a statement that technically it is defective from day one. That's how we are suffering.
No, I don't understand, but what I have visually seen from the materials that I got on the last hearing, and then when I viewed that hill, maybe that's not the work. But this is not the way you do it.
Last summer, all those rock barriers that was installed were all damaged.
And Mr. George, in northeastern region, iron barriers, iron fencing, how long will it sustain?
It didn't last even one season.
How long will it sustain? One rain would rust it.
It will not rust it.
I've seen it. It has come out. Many places you have taken it out and kept it in one side.
It came out because the volume was too high and came from much more than height it was expected.
Because that hill has to be hill. You cannot say that, okay, from here you don't fall. Above you fall, I have nothing. You can't say that to the hill. That's a natural thing. It'll fall.
That's why this time the DPR consultant have
And okay. You have done that. What is your view of protection of these slopes where there is some mud left, soil left? I've seen it's barren in many places. Rocks have been exposed now. But where there is actually some mud left, where some plantations can be done to protect, there are now systems, plants are there, which will protect the roots are very strong. It goes in, it protects the land, the slopes.
All this kind of analysis is already done, including the SRT, ERT analysis, which actually go deep through the strata. And
strata is now its maximum places. It's the rock, literally.
There's a soil mixture in some area.
Very rare, very rare. Above there is something.
Yeah, there are particles.
But this 2 months thing, you will be again, after say maybe a year, again we will have to do the same exercise.
No, it's in the pilot stage.
I know that. If your DPR comes also, will you be in a position to work during the rainy season?
That project will take little longer. It may
No.
take one.
So what about the protection during the rainy season? How will the people, because that's a major road, people are using it. How will you ensure that the vehicles are safe?
This season, we will again close that latches of the road, left-hand side. We will only allow, during monsoon, we will only allow traffic through the right-hand side.
See, you are putting the people of the state into trouble,
But we will
inconvenience, because this is your mistake. This is a big default on your part.
We will be taking whatever measures.
Yes, Mr.
Just for Lordship to be there. First step he took 3 years back was he put wire mesh everywhere. And the opinion of the expert was that the wire mesh would be sufficient enough to protect.
No.
It was a total failure. So crores of money spent. And thereafter he came out with this second.
And what about the defect liability period of the earlier contract?
No, it is
10 years.
It's continuing.
Yes.
So he'll be doing the
They
work.
will be doing the maintenance.
When have you said
So,
that?
Manoj, let it be, instead of 2 months,
We'll
they put that there is a retention issue of 2 months. Then Lordship, if you go back to paragraph 3, Manoj, defect liability is down so that we conclude paragraph 2 parawise.
yes.
Now, with regard to 164, That with regard to feasibility study report of proposed viaduct at Chennai 164, Manoj, it is the right after the river, to the big landslide, that portion. Zubza. It is stated that detailed design and drawing meeting of Venture Bridge proposed for the Challenge 164 has been reviewed by IIT Gauhati. Estimates for construction of the said bridge is underway and will be processed for tendering. Why not, if the authority engineer, we kindly be allowed to highlight on this, because last 2014, because of this area, the road was closed for more than a month because of a heavy landslide.
The design of the bridge is already done by the India consultant, which was vetted by IIT Gauhati.
And now you are going for tendering.
Yes.
So another month.
Should be time bound or should be then.
Maybe take.
Yeah, we should the tender. No, you've not issued the tender. So by issuing the tender, you will still require 1 month time for the bids to come in. Thereafter, another. Okay. Then what about the third one, river protection? You have tendered, bid due date is 13/2.
Yes.
So by March, you can have the contracts done. Status of precautionary year-round connectivity and prevent. It is stated that STMC contract is currently, STMC means
Maintenance contract.
is currently under force. Additional contracts may be required to be invited from time to ensure that maintenance and route the clock connectivity.
Malot, on paragraph 6,
Hmm.
that is for damages, why factors for that anticipated in the DDR. You should also go to paragraph 6, the only blaming act of God.
Well, as I mentioned, the detailed DPR study is happening now only. This all whatever precautionary measures or whatever work was.
No, if you say that, my question again would be reiterated as to why this was not factored in when you did the first thing.
Because of this short time, because all of single class and emergent measures.
The construction is on since 2019.
Yes.
So one thing we can do, if that be the step, Mr. George, we can have every year a contract, we do it, forget it, again next year we'll have the same thing done, forget it, then again come back the year after.
This time it is pending.
Hopefully.
Hopefully. All this analysis.
Then,
Mr.
answer the question, not to, if it liability in other ways, not to be basing in paragraph 7.
So this subsisting contract, the obligation under package 2, are they doing it?
Yes, they are right.
They are meeting.
There's any shortfall, we are working with their respects.
Mr. Masa,
Okay.
what we do is, this para 6, we will keep it for the time being. We will consider it. Let them, we'll not put a hindrance in their thing.
Okay.
What has happened has happened. Let us see that in future, at least the things are normal. What we do is we give the NHIDCL authorities another month. Let's give them a month. We'll ask them to expedite the tenders,
Okay.
the tendering process, with regard to 164 viaduct.
Okay.
With regard to the river protection works, tenders have already been issued. 13/2 is the date. So by next month, maybe they'll be in a position to finalize that. And with regard to this packages 1, 2, and 3.
Logic with package 3.
Hmm.
Logic, physical progress is only 80%.
Hmm.
And although the extended time granted to package the contractor is still March. So I would like an undertaking from the respondent, from the contractor, when he will complete the project.
For the contractor, as far as package 3 is concerned, also, has already been stated that Danish 164, both are doing also. But now it's beyond my scope of work.
No, within your scope of
Excluding 164.
excluding 164 with package 3, what do you have to say?
Now, Lordship, as far as package 3 is concerned, that's for the information to say it, Lordship. Now, the progress is on, Lordship. It's not that we are abandoning work, Lordship. Full manforce has been put in. We have been given up to March, Lordship. Because of the monsoon season in the last 2025, there were a lot of challenges faced by the contractor.
Now, what is this? What is your projection or your the undertaking that you will finish it by March?
Yes, now the time extended to me is still March. We are expected to finish by then.
Okay. When till March 31st you have been extended?
Yes,
So let that be recorded, Patrick.
Okay. In
But if you extended only up to 3rd March.
3rd March.
yes. Yes.
So he undertakes that he will finish it by 3rd of March.
Yes.
We'll see that. We'll see that.
It's still March question.
March,
Still March.
3rd of March, that is the date given. We are not extending it. You finish it by, you still have 1 month time with you. And it's a dry season going on.
Yes.
Oh.
No, Lordship, we got the order direction in paragraph 4, the state portion. Lordship has traveled, so I have nothing much to say, but after Hornbill Festival, the construction of the road by the from Mandir onwards, which fall within the jurisdiction of the state government, is in deep slump. They have gone to sleep. Maybe they are waiting for the, maybe wake up in the next Hornbill. And Lordship, you see, direction was there. One has been sanctioned, paragraph 4, Lordship passed with the Lordship's order, and it appears that in spite of the direction, the contractor is yet to appear, and there is nothing is happening after Hornbill.
Okay, we'll go one by one. In pursuance to the directions passed by this court, wide heard Mr. T. Masa, learned counsel, senior counsel, amicus curiae appearing in the matter. Also heard Mr. S. George, authority engineer, NHIDCL, and the rest, can you just take it down in a piece of paper? The respondent's name, advocate's counsel's name. So, Mr. Masa has taken this court through the order passed by order dated 25/11/2025 and has submitted that a compliance affidavit has been filed by the NHIDCL authorities, that is the respondent number 6 and 7 in the matter. Mr. Masa has taken this court through the said affidavit, contentions raised in the said affidavit. This court has also heard the clarifications given by Mr. S. George, authority engineer, NHIDCL, with regard to the queries raised by Mr. Masa in the matter. Fuso, para. With regard to the packages number 1, 2, and 3, Mr. George, authority engineer, and Mr. S. George, authority engineer, NHIDCL, has submitted that the detailed project report with regard to the slope protection measures for the entire stretch of the hill involved is under preparation, and he submits that the same would be completed by on or before, Mr. George, on or before, within a further period of 2 months from today. With regard to the proposed viaduct at chainage number 164, Mr. George has submitted that the design and drawing of the same has been reviewed by IIT Gauhati, and the estimates are under preparation, and the tender involved in the matter would be issued shortly.
Well, we are also putting a major bridge,
Okay, whatever is involved there. With regard to the status of river protection works, it has been pointed out, it has been highlighted that the tenders in the matter has already been floated, and the last date of submission of bids is on 13/2/2026. It is submitted by Mr. S. George that a final shape with regard to the submits that the matter would be ripe for issuance of contracts in the matter by middle of March 2026. So, while the DPR with regard to the DPR with regard to the finalization of the DPR for the packages 1, 2, and 3, this court requires the NHIDCL authorities to expedite the matter and ensure completion ensure final preparation of the DPR on or before 15/3/2026. Full stop. On the next date of listing, the update with regard to the completion of the said preparation of the said DPR shall be placed before this court by the NHIDCL authorities. With regard to the proposed viaduct at chainage number 164 and also construction of a major bridge in the said area, the same having been projected to be the DPR for the same having been projected to be approved, the NHIDCL authorities shall forthwith proceed with the tendering process to ensure the completion of the same by March 2026. Complete tendering process, not the award, tendering process by 2026. So, next, with regard to the works pertaining to river protection in the area concerned, the tenders having been already floated and the last date of submission being projected to be 13/2/2026, the NHIDCL authorities shall thereafter, after last date of submission of bids is crossed over, shall process the bids received so as to ensure that the contracts in the matter can be awarded by March 2026. By March 2026, Mr. George, March 2026, 26 award can be done. So, the NHIDCL authorities with regard to the above three issues, that is with regard to the finalization of the DPR for packages 1, 2 and 3, the works works of viaduct and the major bridge at chainage number 164 and with regard to the river protection works, shall place a status report before this court on the next date of listing. The contentions made by Mr. S. George, learned authority engineer NHIDCL, has brought to the forefront that there is a requirement of further time. There would be a requirement of further time for completion of the basic required elements for having the works involved completed in the manner required so as to have the road working throughout the year. So accordingly, the NHIDCL authorities are directed in the meantime to take all requisite steps as would be called for, from time to time to ensure that the road in question is kept open for traffic all throughout the year till the works thereof are completed in the manner now projected by the respondent NHIDCL. Can be done? Full stop. With regard to package number 3, full stop. Now, with regard to package number 3, the learned counsel for the contractor, your name? N. Mozoi, learned counsel appearing for the contractor, submits that the bid validity period has been, the contract period has been extended till 3/3/2026, and he submits that the works involved would be completed by the contractor by the date till with by 3/3/2026. He submits that presently around more than 80% of the works has been completed by the contractor. Full stop. On the next date of listing, Mr. So-and-so, learned counsel appearing for the contractor, shall submit a status report with regard to the works completed by him and shall also ensure that as per the undertaking given today, the works would be completed by 3/3/2026.
You want to in package 3 and entry for 19, zero professional roads. Have completed more than 90% of roads.
Because that is again, that slope protection is again involved in the DPR that is coming. So your work, I don't know why, how it is being, anyway. What's up? Who is doing the steel bridge? Oh,
To come with the.
okay, okay. A package 3 tata line lihiba. Uporot submits that the works involved in package 3, including the completion of the construction of the steel bridge at chainage number 155. Okay. What's up? Mr. Sorry, I forgot you. I just missed your name. Government advocate. You are the additional advocate general appearing for the state respondent has submitted that.
Hello, let me explain why there is no progress.
Has submitted that the one-time improvement of NH 39 bracketed old from the works involved in the one-time to bracket A apostrophe I would one-time improvement of NH 39 bracketed old from KM K now or M for 172.900 dash KM 185.540 under PWD NH Division -1 Kohima would now be earnestly taken up by the departmental authorities and the chief engineer PWD bracket National Highway, Kohima, Nagaland shall personally monitor the works involved on a day-to-day basis and shall apprise this court by way of a status report of the progress made every week from today on the next date of listing. Will do.
And what happened to
So,
SM?
in the event the said progress report is found to not be submitted on the next date of listing in the manner indicated here in above, appropriate order as would be required to be passed in this matter shall be considered to be so passed by this court.
Notice,
Sir.
Yes, I have already handed over the respondent to 5.
What happened? What happened thereafter?
After that, I did not receive any information.
Oh.
This is actually received the respondent.
That much benevolence you should have shown to this court by taking that information.
Yes.
Anyway, we have got the chief engineer entangled now. I think he will be. This copy of this order would be brought to the notice of Mr. M. Singh, Additional Advocate General, by Mr. So-and-so, to the notice of the Chief Engineer, PWD bracket National Highway, Nagaland, and to the respondent number 21, that is SEMP and Co, Lower Agri Colony, Kohima, Nagaland. Also, the registry to list this matter again on on 18/3/2026, on which date the NHIDCL authorities as well as the chief engineer PWD bracket National Highway shall submit their respective status reports as directed herein above. This court requests Mr. S. George, Authority Engineer NHIDCL, to also be present on the next date of listing for assisting this court to take the matter further forward.
So when is listed, okay?
And put it on 18th. 18th. We're not just for the status report. Let's and Mr. Massa, please be very vigilant. If something is to be done, it will put one more line. Put one more line. Put one more line. You are assisted by Mr. Sentinel so-and-so, learned counsel, assisting Mr. T. Massa, learned senior counsel, amicus curiae, is granted the liberty to make a mention of the matter before the next date of listing in the event anything further urgent comes to the notice of the learned amicus curiae.
Not as absent. The contractors were put it from.
For admission, item number 3.
Yes, madam.
My senior, Mr. Ejiomi, is the amicus in this PIL, my lord. However, since he's indisposed today, I request if this matter can be taken up next week, my lord.
What about this additional affidavit? Respondent number 10.
It will have been filed, my lord. We have already-
Copies to all the parties.
If my senior can be there, the board next week.
When this contract is concerned, 100% has to copy.
No, we'll have that thing only from the amicus curiae. Let the amicus curiae go through that.
What is the name?
A prayer is made on behalf of Mr. A. Zimomi, learned counsel, amicus curiae in the present matter for an adjournment in the case on the ground that he is presently indisposed. The learned counsels for the respondents have submitted that the affidavits as directed by this court on the earlier dates of listing has since been filed. So, on the next date of listing, the learned amicus curiae shall apprise this court of the further steps that is required to be taken in the matter, basing on the affidavits filed by the respondents in the meanwhile. Respondent number 10 in the meanwhile. Also, registry to list this matter again next week.
Yes,
Madam, next week. On 11/2/2026. Everybody, just take down, just write it down on the paper. I have this very bad habit of forgetting names. Can't help it. It's a manufacturing defect. Oh.
For admission, item number 3.
We are eagerly waiting to hear you, Mr. Jam. You are Longkume. Yeah. Okay. You're for the state.
Yes.
Oh, yes. I'm sorry, Mr. Zamir. You have to now address us. We are waiting for you. Now you've got to raise compassion in our hearts so that we can pass a direction in your favor. Where is that? Devobrata Tiwari, 2005, 25. I had asked them to take out a copy, file, order. Albert was here in the morning. Albert was here in the morning.
No, not.
Somebody I asked, somebody said that they'll take it out. 2025. Give it to, bring it here. Yes.
As far as this 18 years, passing of 18 years is concerned, I cannot dispute that now. Because my father passed away in the year 2008. Fortunately, the first read petition when I filed in the year 2017, I've made a specific prayer in my first read petition that I approached the authorities in the year 2008, immediately one after my that passed away. Lordship, I have also made 2 other specific amendments, Lordship. In the year 2013, in the month of May as well as in the month of June 2013, I have approached the authorities for 3 separate occasions. Now, to self-consider, forgive my application. Now, being a Greek, I was compelled to approach this one by filing a read petition, the first read petition, which was numbered as WPC number 34K of 2017. what we'll find in page number 15. Now, if I may, the law detective laws, just one paragraph, page number 15. This was disposed of by order dated 6/4/2017. 2 pages order was given. If I may, the law to read.
Please do so.
Petitioner's case is submitted by responsible that is one lead so was appointed as responsible in the police department of Governor of Nagaland on Toronto, died in August on 12/1/2008. When he was posted to Kohima Police Control Room, leaving behind the mother of the petitioner himself and 3 other daughters. Since none of the various family members are employed, the petitioner submitted an application to the FP Council under whom his father served for appointment in the Department of Corporation Crown in the month of February 2008. In spite of verbal assurances, the petitioner was not appointed as requested. Therefore, he submitted another application on 9/5/2013 to the SP number 3, which was duly forwarded to the Director General of Police. While letters in service. Immediately thereafter, the petitioner also submitted another application on 17/5/2013 to the Director General of Police, Nagaland, requesting for appointment on compassionate ground. So far as nothing has been done to appoint petitioner to any government department. The petitioner is a class 12 passed under the Nagaland Board of School Education, and he is well qualified for appointment to the constable in the department. Therefore, expecting positive response would come forward from the authorities concerned for this appointment, and at the same time having no means to file a case to gain his right, the petitioner remained quiet for quite some time. After coming to know that he can avail assistance from the Legal Services Authority of the state, he approached the Nagaland State Legal Services Authority for legal assistance. In order thereafter, he was able to come to this court, claiming his right for appointment at the compassionate ground. The letter counsel for the petitioner further submitted that under the Government Office Memorandum dated so and so, issued by the Governor of Nagaland, family members of permanent employees who died in others are entitled to professional employment, and as such, the scheme, son of the government servant is also one of the eligible persons for appointment. They operated portion cost. Now, I have considered the prayer of the petitioner and produced the documents filed in support of his claim, and I find that he is entitled to be appointed in the department where his father served and died in harness on professional ground. The respondents are therefore directed to appoint a petitioner in any job to which he is eligible, also to as per the scheme provided in Government Office Memorandum above mentioned. So it has a specific direction was issued, and this honorable court, the level single judge has observed that he is eligible to consider the scheme of 2012, which was holding the field at that relevant point of time. So that was the specific direction. This respondents did not comply with that direction. So I was compelled to approach this and court again by filing that PPC 291 of 2017. Go through the page number 52. Page number 52. Now this is a very important one. The order, the third paragraph of the order. May I read it out?
Yes.
This is order dated 16/8/2018. It is submitted by the also for the petitioner that after the death of his father, late so and so died in harness while serving as so and so. Also, so the petitioner approached the concerned authorities for appointment of professional ground under the died in harness scheme. However, the request of this appointment has not been considered hugely. Therefore, having no authority, the petitioners approached this form 24/22. The letter also submitted that there is a scheme for appointment for supposed to the son and daughter of government to die in harness in any group C or post under the government of Nagaland, which was notified by Office Memorandum 2012. Amended from time to time regarding the percentage of vacancies to be reserved for applicants under the scheme. Therefore, the petitioner is entitled to appointment to any suitable post under the scheme. Now, this paragraph is very important. Mr. So-and-so, the government advocate, as directed by this court, order dated so-and-so, has submitted a copy of the letter written to him by Assistant Inspector General of Police, Governor of Nagaland on 31st July 2018, where it has been clearly stated that the petitioner is entitled to be considered for appointment under the scheme. He has been placed in cell on this very important lordship. In the waiting list of persons awaiting appointment under compassion ground, another aspect lordship. It is also stated in the letter that there are 6 posts of possible length vacancy at the moment lordship. Serial number 1 at a relevant point in time, and there were 6 available vacancies lordship. So on the basis of this communication, the petition was closed with a direction. Lordship now coming to the direction. The last paragraph, in view of the submission of Mr. So-and-so and the contents of the letter of so-and-so, the submission of so then we go that okay, I'm considered these are petition is eligible for appointment under compassionate ground under the die enhanced scheme. Therefore, the respondents are directed to appoint him one better post responsibility indicated in the letter. If it fails in the report of compassionate appointment, and if not to appoint him as soon as vacancy arises in that category. The action is very clear, Lordship. So it will be disposed. Lordship, can you come to page number 54? This is the letter which the Venerable Judge has referred, which was produced by the Venerable Republic. 31st July 2018, and the contents, page number 55, Lordship. Reply, if I may be allowed to read the reply, page number 55, Lordship. May I read, Lordship? Yes, Mr. So. Who expired for the prolonged illness? Yes, arranged is maintaining. You will list all the applicants' claims for appointment of professional law. Yes, the applicant is in fact enlisted in serial number 1 of the present list maintained by 24 office. 6 posts of responsible is lying vacant. The resultant vacancy arises for retired from service. So this was the letter which was communicated by the Superintendent of Police to the Director General of Police, and this letter was placed before this honorable board before the nursing judge. And basing on this letter, the petition was closed. A also file continued, but the contempt petition was closed on the ground that there was no specific time frame given by the nursing judge. So, which is why I was compelled to approach this honorable board again in the year 2020 by filing WPC number 141 of 2020. We just imputed this appeal. Page number 117. The actually and what we just imputed this appeal. Now, when the real petition was filed for the very first time, the state has raised a question of facts, as well as a question of law.
Principles on power, one word says. This is happens probably but it
This order was passed on 12/11/2024, right? So this is basically reiterating what the state of the stand of the state was in the earlier round of litigations, 2017 and 2018. This court found that the state having projected earlier that you will be appointed and there are vacancies available, could not have subsequently made a volte-face and taken a plea that the 83 OM was not factored in at that point of time, and 83 OM having specifically provided that for grade 3 and grade 4 appointments, it should be 100% local candidates. 20% of the technical posts are open to all. He can be considered under that 20%, provided he has the technical qualification. Unfortunately, he does not have the technical qualification. Now tell me one thing. This 83 is still holding the field?
Yes.
83 is still holding the field. Compassionate appointment is nothing but a direct recruitment with relaxed procedure. It cannot be against a promotional post. It has to be against a direct recruitment post. Now, when the law of the state is that for grade 3 and grade 4, there cannot be any appointment made of non-locals, then how can that be ignored even for compassionate appointment? Even if it is not specifically factored in the OMs, because this is the general law.
what my respectful submission before the letters you look at this. Since the scheme for compassionate appointment.
So your
It's a-
submissions before us will not be respectful.
Now I've come to the findings of the text.
Okay, okay,
It has already been
okay.
before the findings. First notifying, you want to take submissions first.
You have to.
Yes.
Mm.
It's a welfare scheme, not. It is for the employees who died in this one. Whereas my respectful submission before this 1983 scheme, it is general in nature for all the general posts, not. Whereas this scheme, we had 2012, which is later on amended in the year 2015, the scheme is for a welfare scheme for those only for those employees who die in harness. Now
That is what I'm trying to ask you. That's the area of concern.
Yes.
Now, 83 has delineated who can be appointed. Now, this is just within that who can be appointed, compassionate appointment. So now, can the 83 scheme, even for the purpose of compassionate appointment, be ignored?
And Lordship, my respectful submission, Lordship. The state was aware of the existence of 1983, and the compassionate scheme is silent on 1983.
Need
has
not
been-
be, because if that is there already, that is there. That is there.
Lord.
And this 20% thing would also be there. The learned single judge has gone on the line that you had made a submission. Now you cannot make a volte-face. That's all. The matter whether 83 would be applicable or not applicable has not been gone into. What do you have to submit on that?
Lordship, in respectful submission, being aware of 1983, as you have mentioned, if that reservation is to be followed even in the 2015 or 2012 this memory. And for the very first time, they have raised this contention in my third grade petition. On the first two grade petitions, Lordship, this contention was still raised. When the state is also aware of the existence of 1983, this is just to deny the benefit to me, Lordship.
They have brought it in the third rate petition.
No,
Okay. Anything more?
that is my response.
We'll hear you. Let us hear him. Something. Yes. Why did you make those two statements before the court, learned single judge in 2017 and 2018?
At that point of time, the surety list was maintained as per the union policy, and then the concerned officer, he was at that point of time, as per the list, he was at 1, and then after the
No, how did you maintain that list? What was when you had 83?
yes,
When you had 83, why did you maintain that list? And Mr. Counsel, this instruction is being given, page 55. Where is that letter which was relied upon? It just took us 52. No, that 55.
54 or 11 and 55.
This 55 letter is issued by an authority, it's the superintendent of police,
yes,
and that to the director general.
yes,
So both the superintendent and the director knew about this.
yes,
So they also are deemed to know about 1983.
yes,
So his contention that compassionate appointment is for employees DHOS 83.
come to that.
Hmm.
I'll just take you to page number 35.
Hmm.
Page number 35, which is the OM of 2015.
Hmm.
Now,
Hmm.
I want to refer to clause 7, page 36.
Okay. Okay.
Applications under this scheme should be eligible and qualified for the post in all respects under the provision of relevant recruitment rules. No relaxation is eligibility will be made in any circumstances except to the extent provided under this scheme. Thereafter, by a person appointed under this scheme shall be treated as the date of his or her regular appointment. All departments shall maintain the way these ecological order for commission appointment. An application will be given the value list number on the sheet of the application. Now,
Where is the 2012 scheme?
top scheme is
The date of the employee is on
2008.
8. So prior to 2012, there was no scheme.
Yes,
No scheme.
it was only after 2012. And rule 9 also.
Where is 2012 scheme?
In page number 154.
134.
7, rule 7 also.
This is refers to another 2002 scheme.
Yes, well, the
Okay.
rule 9 also. It says it has to get the clearance from the PNA department. So we have sent the proposal to the PNA department, but the PNA department has turned down. So the control stating that the oil of 2015 should be read along with the oil of 1983. What is the standard destination for battery and photos? It will be not because
Done. So when you went to the PN, then this these people they don't know so many. And even if we told that he was entitled, but now after 20, 24 years. Mr. Counsel, another query. Last order of this court is of 2018. And the contempt was closed on 19.
19,
Then you approached this court again in the year
2024.
2021 year. Okay. But what will we do? You gave him a false hope. He was still standing like this that you will allow him entry because of your false hope. That is much after the time. So what? See, he has built up a legitimate expectation. How can we ignore that?
we have already communicated him about our inability because his case.
No. Your inability came sometime later after 2020. But from 2008, you were assuring him daily morning he comes to your office, ho jayega, wait. He is waiting. He has not even tried for any other job. Oh, that survival is no survival. So you got to compensate. What do you say on that?
Hope I can go against you.
Then what about your statement before the learned single judge in 2018?
Because before without the clearance from the PA, we say
Who has filed this appeal? Who has filed this appeal now?
State.
State means which department? PNR. Then it's filed by the home only.
Yes, sir.
So the assurance is by the home.
Yes.
So your home has to pay him now.
Yes, sure. We are going to set for consideration.
But in 2018, you made a clear-cut statement.
Yes, we will consider.
That we'll appoint him.
Yes, for consideration, we have set the bounds.
So how can we ignore that? The learned single judge only proceeded on that lines.
Yes.
So what do you have to say on that?
No, but how can I bypass this 1983?
So when the undertaking, when you send the matter to the PNR department, this order of the court was also sent.
Yes.
Why did they not take any action against those persons who made a wrong statement before this court?
The court consideration we have as per the oil.
Then without the PNR's approval, why did you make a statement before this court?
Yes. So, my lord, if you, my lord, page 36, rule 10 of that oil of 2015. You know, all departments should amend the respective service rules. Recruitment rules will make the provision.
Oh.
Any dispute arising out of.
There is no, sir, no recruitment rule. The OM itself, it would be elevated to the stage of a recruitment rule. It will hold the field.
But if any dispute arising out of the provisions of these schemes of it shall be referred to the P area. So we have referred to the P area because there is confusion.
Okay, we'll consider. Dispose it of. See. There are some criminal matters I think you will have to take up. Disposed of, dismissed, sorry, allowed. I'll pass the orders. I'm sorry, sympathies are with you, but the compassion is not coming out after such a long lapse of time. Read Devabrata Tiwari. The Supreme Court had added a line there. Delay on account of the applicant as well as on account of the department. The very intention of appointment on compassionate grounds, that is the immediacy required, is lost.
The pain of the litigants before the institution also, because there were two other.
The problem, Mr. Counsel, is that this is an exception to the rule. And what is a compassionate appointment is that this appointment has to take place proximate to the time of death, because it is the financial constraints faced by the family on the date of death of the bread earner that is the underlying factor. This cannot and should not be allowed to continue. Once you have crossed that threshold, then finished. Because see, this post will now be sent for open competition. On merit, somebody will get it. Family has survived. You have a pension. There are many people in this country who are surviving without anything. We'll have to be, it has to be balanced. At least your family has survived on the pension drawn by the drawn on account of the services of the deceased employee. Compassionate appointment is not a vested right which can be exercised at so and so. Compassionate appointment should be provided immediately to redeem the family in distress. It is improper to keep such a case pending for years. Then it goes on to say, where did I give you a copy, man? The object underlying a provision for grant of compassion is to enable the family of the deceased to tide over the sudden crisis due to the death of the burdener, which has left the family in penury and without any means of livelihood. Out of the pure humanitarian consideration, having regard to the fact that unless some source of livelihood is provided, the family would not be in a position to make both ends meet. So and so, having regard to such object, it would be of no avail to grant compassionate appointment to dependents of deceased employees after the crisis which arose on account of the death of a breadwinner has been overcome. Now, when Supreme Court says this, how can we? Sympathy is with you, but can't help it. We'll pass the orders.
For admission, item number 4.
Lord Learned Counsel for the appellant, Mr. Cynthia. So, the present appeal has been filed under Section 446 BNSS / Section 374 CRPC, assailing the impugned judgment and order dated 18/3/2025 and the impugned sentencing order dated 24/3/2025, passed by the Learned Principal District and Session Judge Dimapur, Nagaland, in GR 485/2018 in connection with Tipupar PS case number 52 of 2018, by which the appellant was convicted for the offense under section 364A IPC and sentenced to life imprisonment. Stop. Issue notice.
No, admit it.
Okay. Learned public prosecutor enters appearance, Mr. Tipapong enters appearance for the state respondents, and therefore no formal notice is called for. So the appeal is admitted for hearing. Call for the trial court records from the court of Learned Session Judge Dimapur. Stop. List after 4 weeks.
Much better.
For admission, item number 5.
And this is all. First of all, corrections on the available ceremony for all respondents. Since the consent.
You take your seat. You're for the respondent.
Yes, sir.
Let the appellant first do the needful. The honors are with him now. Why are you taking it away? Yes, Mr. Counsel.
I made proxy counsel appearing on.
Oh, we will hear you. We will hear you. Just point out a defect here, one defect, and you have the order. Otherwise, we are dismissing the appeal.
See counsel, I have not access to the file.
Not access to the file. Then you should not have appeared. What is the reason the main counsel is not here?
My lord, this is item number 5, my lord.
Yes. You
My lord, I
have.
am up here.
Okay,
My lord, I am
fine.
up here. Yes, my lord.
Yes, what is your submission?
My lord, my submission is that, my lord, kindly come to,
Yes, Mr. Counsel.
my lord, I am challenging my impugned discharge, my lord. That is 27/3/2012, my lord.
Your discharge order dated
27/3/2012, my lord. Impugned discharge.
27.
3/2012.
Okay. Why was the discharge made?
My lord, my contention is that, my lord.
No,
I
forget
was
your contention. What is the contention of the respondents?
My
You
lord,
have submitted a resignation letter.
No, my lord, they are claiming, my lord, that was a
Forget it.
resignation letter, affirm on affidavit I have filed over there. My lord, but that
Notarized
I am
affidavit,
not aware.
notarized
Yes, my lord,
affidavit.
notarized, yes, my lord, notarized, and that
Date,
is my
date,
contention.
date of that affidavit.
My lord, that date, my lord, when we were served with that affidavit in opposition, then only we have got that notarization. Earlier than that, my lord, we hadn't got. And that also went to when we have filed this appeal, prior to this appeal, the writ petition was pending, my lord. My lord, I'm just providing, my lord, that affidavit in opposition, annexure 6, my lord. 6. Annexure 6, my lord. In that affidavit is also enclosed by them, my lord.
Page.
My lord, I'm just coming, my lord. My lord, that is page number 5858. Yes, my lord. My lord, see, my lord. It's a notarized, my lord. Even for a birth certificate correction, my lord, we have to appear before the first class judicial magistrate, my lord. And from the service, my lord, we will giving a like notarized affidavit, and there they will be claiming that I have signed, and then after that, my lord, I will be discharged from the services.
Okay. And
My lord, this is my
the discharge certificate was received by you.
my lord, discharge certificate. My lord, the annexure P2, my lord. That was an appointment letter, my lord.
That
then,
was
my lord,
given to you, Mr. Counsel. That was given to you.
My lord, discharge was. My lord, just give me 2 minutes, man. My lord, order was there, my lord.
No. When you were sent out from service, was
Yes,
a
my lord.
certificate given to you?
My lord, on the same day, my lord, it was not given to me. I was in the assumption that I am taking a
Okay.
medical
When was it
leave.
given to you, Mr. Counsel? When was it given to you?
My lord, many things appear after filing of this writ petition, my lord. Prior to that, I was not.
That was a copy annexed to the writ petition, that discharge certificate.
My lord, that is there, my lord. That is there. But we had claimed, my lord, how this discharge came when I have not signed anything.
Forget, Mr. Counsel, we are not on that. We are on the fact whether a discharge certificate was given to you when you were sent out of service.
It was sent out of service in 2012 itself. And that copy has been served on me when I prayed for the prayer for reinstatement into the service, that is Annex P5, page 45.
Where is your statement in the writ petition that this document was given to you only after you made an application before the authorities
My lord, paragraph number 17, my lord.
of the writ petition?
Page 10, appeal, my lord, this appeal.
Appeal.
Yes, my lord. 10, page 10, 17. The petitioner, my lord, may I be permitted to read, my lord? The petitioner received the communication number this dated 21st October 2015, where was the respondent authority denied the petitioner claim for the reinstatement in service. The constitution.
No, this is reinstatement. Where is your statement with regard to the fact that you were not given a discharge certificate when you were sent out of service?
My lord, then para 21, subsequent page, my lord.
Para 21.
Yes, my lord, that I am not claiming, my lord. I am claiming, my lord, this is there, my lord, discharge notice, an order 31, 2012 March, that was being given to me in a form of a reply. When I was agitating that I was in a medical leave, why I am not being reinstated when I came, my lord. Page 10, page 10, after that 11, my lord. Page 11.
Where is your writ petition here?
Writ petition, my lord.
You have not annexed the writ petition here?
My lord, if my lord, then I am filing, my lord, I am seeking a leave so that I will file a.
No, will not trouble you, will not trouble you. We can get it.
No, my lord, it's not troubling, my lord.
No, we can get it from
I
you.
shouldn't trouble court, my lord.
District. Don't worry, Mr. Ansari, we'll take it up after some time. We'll have the writ petition records called for. Get
My lord,
the
today only.
today only.
Oblige, my lord. Oblige, my lord.
We have very short memories. What goes in should go away otherwise.
My lord, more shorter we have, my lord.
See, 144.
Oblige, my lord.
You see?
144.
We'll take it up after a few items. Let it come.
144 or 23.
Oblige, my lord.
We'll take it up after some time.
Oblige, my lord.
For admission, item number 6.
Pass the order. Delay confirmation.
My lord, sir, I pray for the delay of the flow. 767 days.
Same thing. Same thing. Mr. Sentianga, in item number 6, it is 6767, and in the other case, it is 6085.
Yes, ma'am.
Yes, Mr. Counsel, we are condoning that delay. We'll hear it on merits delay. And what about the appeal? Should we issue notices today?
Appeal also.
Appeal is already numbered. We can issue notices in the appeal also.
My lord.
Admit the appeal,
My lord.
take it for done. 6-7. IA 44 and IA 45 disposed of. I passed the order. It's there. Don't worry.
Much of it. You do it, sir. Lordship, in both the criminal appeals, if the LCR can also be formed.
Yes, we are calling for the. No, it's not LCR this day, it's TCR.
TCR.
I've seen that it is written as LCR. It has to be made TCR. Trial court records.
My lord. You do it, sir.
Just go through it and read it. Just go through it. It's nothing else. Yes.
For admission, item number 8.
May I please, Your Lordship? Your Lordship, this matter has been kept pending for a considerable period due to the fact that, my Lord, there was a similar matter pending SLP in the before the Honorable Apex Court, my Lord. And the SLP which was preferred by the state respondents was dismissed, Your Lordship, and I am yet to obtain the order, Your Lordship. So,
SLP order.
Yes, Your Lordship.
Oh, that is here. 35 of writ appeal number 35 of 2022. Matter went up
Yes, Your
from,
Lordship.
so that has been dismissed by the Apex Court.
Yes, dismissed, Your Lordship.
The order is here.
Yes, so I'm here to obtain the order. So if this matter may be.
We have the order. We have the order, madam. We are helping you with the order.
More, Your Lordship.
We are helping you with the order. Yes.
Your Lordship, I'm not the arguing confidence matter as well.
That is the main.
That is the main thing. That should have come first.
Lordship, I will come prepared on Saturday, Your Lordship. I'm not prepared, Your Lordship. So if Your Lordship kindly give me some time for preparation, Your Lordship.
Such favorable plea, how can we say no? Okay. You're 40?
I'm for the review petition. Your
Review
Lordship.
petition. State, review petition. A prayer is made on behalf of, a prayer is made by the learned counsel for the petitioner for an accommodation for the day to enable her to prepare and make her submissions. Full stop. Prayer accepted. Registry to list this matter again on Madam, next week. The next Wednesday.
Your Lordship, Saturday was supposed to be on.
11 to 2026.
Much obliged, my Lord.
The Saturday plea that you have taken today should be taken in all matters from today onwards.
For orders, item number 9.
Statement of the girl, 164. Madam, one thing I don't understand. If payment customers or something, then we can hear this. But why is this not being written by 160 statement? This should not be part of the shipment.
Normally, the police people used to put it.
May your lordship.
So this should not be there in the paper.
In the book.
Should not be there in the paper.
No needed.
No need actually. Respondent number 6 is the PW6 is the page 23 and page 43, 164 and this one. She has implicated. Yes, Mr. Counsel.
Lordship, on the last occasion, the Honorable Court has, the government side was to file an affidavit opposing our I for the bail. So
No, the
till
paper book is ready. Paper book is ready. We'll take up the matter for final disposal. Why go for this interim thing? If you're ready to argue, we are ready to hear the matter today itself.
Lordship, then I could request you for a time. It will be impossible for me to virtually argue all these things. Lordship, I maybe accommodated some time.
You are more comfortable here in a familiar setting there. We are also comfortable here.
Lordship, I'm not actually not prepared for the hearing today. Actually.
And that's a different issue altogether. Paper book is ready. We'll not go for
Yes,
it.
yes,
We can go for the final. And the victim statement 164 and the deposition in the trial.
Yes, Lordship.
So basically, the foundational facts have come on record. You have not been able to dislodge it. So make your submissions, we'll see. The learned counsel for the parties have submitted that the paper book in the matter being prepared, the appeal be taken up for final consideration. Full stop. Prayer accepted. Registry to list this matter again on 11. Mr. Khalid,
11th.
no, sorry.
Okay,
11, huh? 11 to 2026.
Oblige, Lordship.
That was the language even exporting. 2 minutes it will take.
For orders, item number.
Okay, sir. Item kitna? This is when only on one basis. But we had issued while sitting last time, this order was issued on 26/11/2022. Why so delay? Why the delay in issuance of notices here? We had passed this order on 26/11/2025. We find that the notices were issued only on 31/1. There was delay in taking steps. Okay.
Oh, you did not
Okay.
take the steps.
Yes.
Here, now of eternal of my senior advocate, for respondent number 5, 7th.
Okay, you have filed your wakalatnama.
Your Worship, I will notify.
Oh.
Your Worship.
Okay, you file your wakalatnama. You are for 5, 7,
5, 7, 9, 10, 12, 13.
5, 7, 9, 10, 12,
13,
13,
14,
14,
16,
16,
17,
17,
18,
18,
20, 21,
20, 21,
22, 23, 24,
23, 24,
25, 26,
hmm,
28,
hmm,
29,
hmm,
31, 32, 34, 35,
32, 34,
35,
35,
36, 38,
36, 38,
39, 41, 43,
hmm,
44,
hmm,
45
hmm.
to 49, still 49. 45, 46, 47, 48.
So, heard the learned counsel for the petitioner. Take down her name, huh? Miss
It's decreasing.
Crisenio, learned counsel submits that she is under instructions to appear for the respondents number 5. Madam, just check up. 7, 9, 10, 12, 13, 14, 16, 17, 18, 20, 21, 22, 23, 24, 25, 26, 28, 29, 30, 31, 32, 29,
21,
31,
32,
32, 34, 35, 36, 38, 39, 40, 41,
no, ma'am.
40,
Not 40.
for not 40, 41, 43, 44, 45, 46, 47, 48, and 49.
Yes.
So, accordingly, for the respondents now being represented by Ms. So-and-so, so-and-so, the service is complete. So, await completion of service for the unserved, for the remaining unserved respondents for another 4 weeks. 4 weeks. Registered to list this matter again on 11/3/2026. Mr. So-and-so, Additional Advocate General, appears for the respondents number 1, 2, and 3. For some, 1 to 4. Okay. The respondents who have entered appearance are at liberty to would file their responses in the matter on or before the next date of listing. Hmm. 5 records. Okay.
All right, Commissioner.
Just send a message to that counsel who was appearing, na? Khalid or something. Item number 5. Just send a message. Item number?
5.
No, 5. He's not there, na? You send a message. Give him a call.
My lord, I'm here.
You are
My
here.
lord, my lord,
Okay.
I'm here, my lord.
Okay. Okay.
My lord is just busy.
Okay. Where is your statement in the writ petition to that effect?
My lord, right now I am not having, my lord,
Okay, we'll do that matter for you. Don't worry.
No, my lord, no, my lord, no, my lord. No, I'm not troubling, my lord. My lord, if this matter to be kept on tomorrow.
Okay,
like,
you have said that the you have said that you have been given that certificate.
Yes, my lord, that I'm saying I'm given, my lord.
So why have you not, if that resignation was not proper, why have you not taken up the matter with the authorities or filed a police case to that effect and waited 2020 to appear before this court? 8 years.
My lord, yes, my lord. I will explain, my lord. This person is from Durgapur, my lord. It's a like small town, my lord. He doesn't know anything. He's only
Durgapur, we have a steel factory.
Yes,
A
my lord.
famous
That is
steel
there, my
factory.
lord.
It's not a
But, my
small
lord,
town.
my lord, my lord. But all that biggest high level person are coming from the outside of that Durgapur, my lord. This person is a resident of that, my lord. He's not well qualified, my lord. He's only class 10 pass, my lord. He was not aware of anything. He was just running from one place to another, my lord. Certainly, he came once in Delhi, my lord, Supreme Court. He met with one advocate. He suggested him, my lord, some advice, my lord. They filed one SLP, my lord. Then it came before me, my lord. Then I suggested, my lord, that
How could he file an SLP? How could he file an SLP without there being any proceeding?
My lord,
He has not filed any SLP.
My lord, no, my lord, he has filed. There was one order, my lord. It is annexed in the writ petition, my lord, to explain
Order
delay why
in the writ petition.
Yes, my lord.
Okay,
Yes, my
let
lord,
us see
that
what
was
it
there,
is.
my lord. My lord, it was a SLP, my lord. It was there. My lord, then
Just
then it came before me, my lord.
There is no order here.
My lord, if it is not, my lord, then I have to bring that on record, my lord. Or else, my lord, I have pleaded that in my appeal, my lord.
Where have you pleaded that?
My lord, I'm just looking, my lord.
Oh, this is BTP.
My lord, page 16, my lord, once, my lord.
Page?
16 of my.
Sorry. I was having a wrong file. Just give me a second. It's a writ application before the Supreme Court.
Yes, my lord. And through
Not
that,
a
my lord,
SLP.
when it.
Not an
My
SLP.
lord, I may be correct.
Okay.
I may be correct, my lord.
Okay.
My
Then
lord, my lord, then it came before me, my lord, by the learned, senior learned friend, my lord. He advised.
Okay, what is the error in the findings of the learned single judge?
My lord, I am not placing such, my lord. We are only going on that, my lord, the discharge certificate which was relied upon that notarized affidavit, my lord. We are claiming that notarized affidavit, my lord. That was I'm not aware, my lord, what is happening, my lord. How this notarized affidavit came, my lord. Second contention is that, my lord, that notarized affidavit, my lord, it was before any notary public, my lord. We shouldn't say much on that, my lord. Why not? It was like a person is getting discharged from a service, my lord. His career will be ruined, my lord. He is only a breadwinner of his family, my lord. Why this notarized? Why not first class affidavit of the magistrate? At least that courtesy, my lord. And then, my lord, this whole thing was placed on that, my lord. Second fold of my submission is, my lord, is that, my lord, if this is so, my lord, why not this thing was being given to me at that time in 2012 itself? Why they have waited till filing of this affidavit in opposition when I have filed a writ petition before this Honorable High Court? My lord, based on that, my lord, and my lord, I'm claiming, my lord, this is my twofold of argument in this petition, my lord. Nothing apart from that, my lord, I have not a very strong case, my lord, that I am admitting very honestly before my lord.
That's very fair of yours on your part. Thank you.
Oh, my lord.
We expect this fairness from everybody. You come to page 42. The query that I was asking you, that is there in page 42.
Yes, my lord. I will read, my lord.
No. Just see the third paragraph.
Yes, my lord. My lord, that what I am claiming, my lord. This discharge was based upon my notary affidavit, where I am saying that I want to.
Once you have been discharged from
Okay,
service in 2012, Why did you wait for 8 long years?
My lord, again, I'm saying, my lord, I am a layman type person, my lord. I don't understand, my lord. Even if you will call, my lord, the petitioner will be present before my lords, my lord. And you will, my lords, if you will ask some question, my lord, the way he will answer, my lord, after so many years, my lord, it will look like, my lord, he is not aware of his rights, my lord. How he will go and claim, my lord. Second thing, my lord, when he approached before Supreme Court, Delhi, he was running here and there. He met one learned senior friend. There he advised him to file an application before the Honorable Court. But that again, I advised him when it came before me through that learned senior friend that this petition should not be maintainable over here.
Anything more, Mr. Khalid? Anything more? You are Mr. Ansari.
Yes, my lord, yes.
Anything more, Mr. Ansari?
My lord, apart from this, my lord, I don't have my lord.
Sorry, we are
My
not.
lord, it's a mercy
The
upon
view
him,
taken
my
by
lord's
the
hand.
learned single judge is a plausible view, and sitting in a writ appeal, we are not inclined to interfere with that.
Interfere, my lord. Oblige, my lord.
Thank you.
Oblige, my lord. I can only try my luck, my lord. Nothing more, my lord.
Thank
Oblige,
you.
my lord.
Yes,
Only
Mr.
mercy from my lords, my lord.
Mercy would have come if there was some material.
My lord, that notary affidavit will not work in my favor, my lord.
But you knew it in 2012 why it was done.
No, my lord, I was not aware, my lord. That's what I am claiming, my lord, in this appeal. That I was not aware of that
Okay.
notarized affidavit, my
Okay.
lord.
Okay.
That only came to me through filing of this writ of that opposition by the respondent. My lord, kindly record in that the submission in that order of which my lords.
It's already recorded in the single bench's order. The same submission was there. It was considered rejected. You have not persuaded us to take a different view. That's all we'll say. Okay, thank you. Dismissed. We'll pass the orders.
My lord, my name to be recorded over there.
Yes,
my lord, in
yes,
the
yes,
order.
Mr. Pansari.
For orders, item number 11.
Please, your lordships. Pursuant to the direction of this honorable court order dated 18/11/2025, your lordship, the service report and respondent number 2 has come. So I seek leave to place the same on the.
There are a here number of RNA based on this also since this year has been considered with the of the single from
Legally, it has to be going to be.
Wait, pause it now. Let's do it.
Learned counsel, Miss Such and Such, appears on behalf of Mr. Aaron Long, learned counsel for the appellant, and prays that the matter may be listed for hearing after 2 weeks as the trial court records have been received. Stop. We'll have to prepare the paper book. Yes. So that will take more than 2 weeks. Anyway, learned public prosecutor, Miss S. Mary, has submitted a copy of the notice which was served on the respondent number 2. Stop. None appears for the respondent number 2 when the matter is called. Stop. Accordingly, this court is inclined to appoint any legal aid counsels here.
Legal aid counsel.
Legal aid. Just suggest somebody. And accordingly, or Cynthia, yes. Okay.
Yes, come forward. These are opportunities you should lap up.
Accordingly, Miss Lovinio is appointed as the legal aid counsel to represent the respondent number 2. The counsel for the appellant shall serve a copy of the appeal memo on the learned counsel for respondent number 2. Stop. The registry is directed to prepare the paper book and thereafter list the matter for hearing after 4 weeks.
For orders, item number 12.
Same. Here also records receipt. Okay.
It's not
Next week, along with the IA.
That's point number 2.
Learned Counsel, Mr. Mo Jamir appears for the applicant and submits that he has filed an IA for praying for impleasement of the legal representatives of respondent number 2. And however, the IA has not been listed today. So accordingly, list the matter on 11/2/2026 along with the IA. Learned PP, Ms. Livika is present. Yes.
For others, item numbers 13 and 14.
Make use of lordships. Both
Report, medical boards report.
By all the data state about 2025, we follow the board directed to consider and medical boards for examining of the applicant and the remaining the nature of the medical treatment required. Yes, I have that. There are medical health implications which require the medical essential law.
No, please, Your Lordship.
But they have not even said that it cannot be done. That was what was required.
Can be done in custody.
Custody or not. That they have not done. So.
Your Lordship, there was a direction, Your Lordship, that to obtain medical report from the Board of Doctors, as well as there was a direction from the court that whether he will be getting the care post-surgery. Now we have got an information that it is not available, the operation is not available in the district hospital. So the nearby will be referral hospital. But now the question is post-surgery or during surgery, whether if he has to do the surgery outside the jail, then how many days that will be required? That is not being actually given by the Board of Doctors. So for that, I think I need 1 week maybe. I tried actually contacting the superintendent.
This is nothing, this we know.
Yes, that's
For
why.
that, we don't require a medical board opinion. Medical board opinion is whether the treatment can be provided while he is in this detention, both pre and post operation.
So maybe some specific order can be passed so that.
It's already there, madam. Para 7. This court is of the view that a medical board is to be constituted to examine whether the appellant can be provided the required treatment by keeping him inside the jail, or the applicant needs special care and after undergoing the surgeries, if required, so.
So, Your Lordship, let me actually give me 1 week so that at least I can take the diary and some steps will be taken into account.
Now, are you providing him the required care now?
Yes, Your Lordship. That too on the last report also we have actually stated that we are providing every care. But now for surgery, now that is the problem now.
Give me a clarification.
This is Central Jail, Dimapur.
Yes, in relation to Mohan. Dimapur and the Board of Doctors are giving that recommendation that he should go for laparoscopic, but that is not available in the district hospital. But now if he has to go outside the district hospital, then they care. Yes, that is not being specified. So sometime a week, maybe next week, so that within this week I will try to seek instruction.
Lordship in the case, and I think all the make pass to ensure.
But that will do.
Make it by next week.
Like,
I am.
this court.
Okay.
Heard Mr. Your Mr. James Newman, a learned counsel for the applicant. Also heard Ms. Livika, learned additional public prosecutor appearing for the state. Assistant public prosecutor or additional.
PP.
Oh, you're the public prosecutor. Sorry, the public prosecutor appearing for the state. This court had wide order dated 10/12/2025, considering the ailments projected to be suffering by the applicant had directed the state respondents to constitute a medical board to examine specifically the issue as to whether the applicant can be provided the required treatment by keeping him inside the jail, or the applicant needs special care and after undergoing the surgeries involved, would be required to have a special care and attention. So in terms of the said direction, Ms. Livika, public prosecutor, has placed on record the report of the constituted medical board. This court has perused the said report and finds that the medical board has not opined as to whether the petitioner, as to whether it would be feasible for the petitioner to undergo the surgeries involved while being under detention, and also as to whether after post surgeries the required care and attention can be provided to the petitioner while he continues to be under detention. Further, the period for which such treatment, such care would be required to be provided to the petitioner. So, Ms. Livika submits that she be granted a week's time to get the said clarifications from the constituted medical board.
Okay, but I'm told that like the board is to constitute only on tri-state. It seems that.
Tomorrow, Thursday. Tomorrow, Thursday. So this is a court's order you got to, because its life is at risk. Raised, so Ms. Livika shall ensure that the set clarifications are provided by the constituted medical board and placed before this court on the next date of listing. Registry to list this matter again on 11/2/2026.
Return this one.
Keep it on the phone. A copy of the medical report. Ma'am, you have a report copy of this? You have a copy? A copy of the report, medical report furnished by Ms. Livika, a learned public prosecutor, is kept on record and marked as X for the purpose of identification. Thank you. This is something we learned from Michael's.
It is also new.
He said you put sign. He gave it to me.
For orders, item number 16.
16 was adjourned as well.
16 is adjourned.
Okay.
Please, Your Worship. We're still unable to contact respondent number 4, the performer. So a week's time may be granted so that we can make a last attempt.
Come to the office note 23/1/2026.
Checking.
Report. So they will deem it to be delivered. Seen the office note dated 23. Seen the office note dated 23/1/2026, which reveals that the notice issued to the respondent number 4 by way of speed post has been delivered to her. Full stop. Accordingly, the service of notice upon respondent number 4 is held to be complete. Full stop. Registry to list this matter again on 11/4/2024 for admissions. What is this IA for?
One is for contribution.
Oh, no, for orders, huh? The respondents are at liberty to bring on record their objection, if so advised. Mr. Additional Advocate General for respondent number 3, and Madam, you are for? And Madam for respondent number 2. Right? You'll be for 1 and 3, or Three tribunal.
is-
One also you can appear.
Also state,
Respondent number one, all for application. Name is respondent number three.
Okay. So can you appear for one also? Earlier notices was received by Ms. Livika
Yes.
for 1 and 3. Okay, fine. Fine. We'll have it on 11th. 11th? 11/4, 11/2 next week. If you have any objections, service is complete on respondent number 4. So matter is ready for consideration. If you want, we can take up the condonation application today itself. 5 days. Only 5 days. Huh? We'll condone it 5 days. We'll have it for admissions. No objection. Hut. Miss So-and-so and Sabka naam le lena, respondent Sabka. The present application under Section 5 of the Limitation Act has been filed, has been instituted, praying for condonation of the delay of 5 days, occasioning in filing the connected writ appeal. So, we have perused the contentions raised by the applicant in the application and finds that the same to constitute sufficient cause under Section 5 of the Limitation Act for the purpose of condoning the delay. The learned counsel for the respondents have also not objected to the condonation of the delay of 5 days occasioning in filing the connected writ appeal. Also, in view of the above, the present interlocutory application, according in view of the above, the delay of 5 days stands condoned. The present interlocutory application stands allowed. Huh? Also, shall we pass this order here or here? Just before the interlocutory application disposal, registry to list the connected writ appeal on 11/4/20.
This will not be present on the 11th, so perhaps on the 18th.
On 18/2/2026 for admissions. That will do.
For orders, item number 17.
Yes.
steps not taken.
Steps not taken for service of notice. Why?
We have taken.
When?
When?
Very sincere, because
Because office note dated 3/2/26 says steps.
You are paying for one.
Yeah. Lots of the entire case, I mean, because few days to keep on record the steps that I have taken. I believe steps were taken to course.
No, you should have routed it through the High Court registry. If it was routed, it would have been here. We permit you to take fresh steps, no problem. Seen the office note dated 3/2/2026, which reveals that the steps for service of notice upon the respondents number 2 to 6 has not been taken by the learned counsel for the petitioner. Also, Mr. Sentinga, learned counsel for the petitioner, prays that he be granted a week's time to take steps for service of notice upon the respondent number 2 to 6 by way of speed post. Also, prayer accepted. Registry to list this matter again after 4 weeks, along with the status report with regard to the service of notice upon the respondents number 2 to 6. Mr. Mr. Siachamko, learned counsel, appearing on behalf of Mr. Gauhati, learned CGC, is present. For the respondent number 1 is present.
For orders, item number 18.
Now this law. All we're asking for by later, we're trying to is really not of the I filed a proposition.
So you want to withdraw it?
Yes, we're liberty to file a petition.
Why?
Because this marriage, if you say some
it appears that there's no legal errors. So you wanted to file opposition already filed.
No, they want to withdraw.
Madam, that I cannot take,
Object.
but only the thing is that my opposition already filed. Let it be reflected.
No, if they are withdrawing, what is there?
But after filing the objection.
No, what is the technical defect here, Mr. Counsel? What is the technical defect?
I'm not a leading concerns.
We'll have it next week then. Mr. Aranwati would be here next week.
Then it is better with the 2 weeks then.
On the prayer of the learned counsel for the applicant, registered to list this matter again on 18/2/2026.
My parents,
Mr.
I know that.
I am Tiling Toloncha, learned counsel for the respondent.
In opposition file.
Respondent is present who submits that the objection on behalf of the respondent represented by him to the application praying for condonation of delay has already been filed.
For orders, item numbers 19 to 27.
Hearing.
Hearing, this is hearing.
Mr. Lordship.
Hmm.
Lordship, here the state has filed an appeal, which are not listed today, that is WA2 of 2025. Here where the learned single judge, they have passed the judgment in line with the Supreme Court judgment. However, the court of the Chief Justice has stayed the learned single judge.
That's an interim direction.
Lordship.
That's only an interim direction. We have a final order here.
No, the final order is that to leave the
Yes, what do you say?
My lord, this coordinate bench is for several orders. And for which I'm covered by those cases.
And what about this Supreme Court orders? It says we are not inclined to interfere with the doing judgment and order.
Yes. Because the question of law was kept open, Your Lordship. So that question of law has to be decided in WA2 of 2025.
That cannot be done here because we are bound by the.
No,
that will be done by the Supreme Court in.
Did not interfere into the question of merit, but the question of law was kept open, Your Lordship. And even the Lordship, I will place the stay order passed by the Chief Justice of the learned single judge judgment. Lordship may come to page 5, para 8.
Just a second.
This is the IA for stay of the European judgment. Page 5, para 8. May I read? Instances have been cited.
Madam, just a second.
Lordship.
Now, which is this appeal? 22 and 2, 3 and 4, what happened? What happened to 2, 3?
Still pending for,
It,
yes, yes.
the orders have not been delivered yet.
Judgment reserved.
No, it's still pending, Your Lordship, it's still pending.
No, here it says that,
It says
different appeal after hearing has reserved the judgment.
the judgment.
Yes,
Para
but
9.
it's in a different case, in a different case. Different case.
I got
Your
it.
Lordship,
I
yes.
got it.
Yes.
So issues are similar.
Is similar. In that case, a direction was given to the state respondent to inquire and to see whether the petitioner were entitled. If they were entitled.
In 2, 3 and 4.
No.
What
not
happened in 2, 3 and 4?
It's still pending. It's still pending for disposal.
No, pending for disposal, CAV. Or, because you say it's CAV.
This but it's not continuing. It is one.
Different, so it's not 2, 3, 4, it's another case.
Okay.
So that other case.
That other case, what happened? Which was,
That in which the judgment was reserved, that case was passed. This one-
Judgment issue.
Passed.
Issued,
Passed.
yes, directing the respondent to make an inquiry. If the petitioner come within the scheme, then
that was by Justice?
Judgment Midru Kalita and the other one I forgot. No.
Okay, no problem. And this 2 of 2025 is pending till
Yes.
2, 3 and 4. And this also the issue is after retirement they have filed.
Yes. So Lordship, my prayer is that this matter should be.
Let's put it on next week. Madam's name is? Oh, V. Sukri. V. Sukri, learned additional AG, appearing for the state respondents, submits that issues involving, submits that writ appeal number 2/2025, writ appeal number 3/2025 and writ appeal number 4 of 2025, involving issues similar to the one raised in the above noted appeals are presently pending disposal before this court and would be required to be heard along with the above noted appeals. Also, prayer is not objected to by the learned counsel for the petition. Accordingly, registry to list the above noted appeals along with writ appeal number 2/2025, 3/20, writ appeal number 3 of 2025 and writ appeal number 4 of 2025 on 11/2/2026. So Madam was successful in getting us off the matters.
And you supply a copy of that judgment also, no?
That's
judgment in the similar case.
because now there will be 2 judgments.
Yes.
One amendment, second one this. So you bring it on record.
For hearing, item number
34.
But the learned counsel for the parties. So this court had admitted the present appeal while order dated 3/12/2025 for hearing and had also called for the trial court records. So the office note dated 31/1/2026 reveals that the trial court records are yet to be received. Also, accordingly, a registry to requisition the trial court records forthwith and thereafter on receipt of the trial court records to prepare the paper book. That will do. Also, registry to list this appeal after 4 weeks along with the paper book after a copy of the same is furnished to the learned counsel for the parties. Finished.
Before June.
Give me a room. So at least some work was there today.
Onun da mention.
Bu projenin mentioned itulah dari kita itu mature ini pasti mana sampai jenuh sih untuk seperti ini cerai ini itu orang untuk kontrol
Bच्चे करना disposal always good. Dangerous money.
이건 랩이 무엇에서 아이에도 섭 디스포즈 코르스 될까 라나. First disposal